All right, case number 24 CR 149, State of Ohio versus Ronald Howen Jr. Are you Ronald Howen Jr. appearing there on the screen marked Ronald Howen?
Yes, sir, Your Honor.
All right, this is a hearing being conducted by Zoom. Mr. Howen's appearing. Where are you at, Mr. Howen?
I'm at the Recovery Council in Waverly, Your Honor.
Okay, all right. His attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is prosecuting attorney Collins. Defendant is charged with 1 count of possession of heroin, a 5th-degree felony. Court has received a plea of guilty form, Mr. Howen, which indicates that you are going to plead guilty to the charge. I'm going to hold the first page up to the camera, and as your name, case number, plea of guilty, do you recognize that paper?
Yes, sir, Your Honor.
All right, and on the last page, page 3, there's a sentence that states, I enter this plea voluntarily. Immediately below that appears to be signature of Ronald Howen. Maybe a junior on there, I'm not sure. Is that a junior at the end, or is that just Ronald Howen?
Yeah, it's just Ronald Howen, but yes,
Okay.
I am junior.
All right. And you recognize your signature?
Yes, sir.
And when did you sign this document, Mr. Howen?
Yesterday.
Now, had you been talking with your attorney about this matter before you received this plea agreement?
Yes, sir, Your Honor.
And did he explain everything to you in the agreement and answer any questions you had?
Yes, sir, Your Honor.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir, Your Honor.
And did you sign this document voluntarily?
Absolutely, yes, sir.
And are you going forward with the plea voluntarily here today?
Yes, sir, Your Honor.
Right, so the agreement states that you understand that the offense is possession of heroin under 2925.11a of the High Revised Code, 4th-degree felony, and that the possible penalties for that are 6 to 18 months in prison, a fine of $5,000, and a license suspension of 6 months to 5 years. You understand that?
Yes, sir, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, sir, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir, Your Honor.
All right, now under the law, Mr. Howland, I'm not required to sentence you to prison for this offense. I can't impose community control or probation, which means that instead of going to prison, you can be put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. If during that period of time the probation department felt that you were non-compliant, they would file a written notice of that with the court, give you a copy. There would be a hearing. You'd be entitled to have a hearing, or an attorney at that hearing. If the outcome of the hearing was that you'd failed to comply, then at that time, the court could revoke your community control and sentence you to between 6 and 18 months, fine you $5,000. And if you were revoked in part or total because of a conviction for a new felony and were sentenced to prison for that offense, the sentences can be ordered to be served consecutively to each other. You understand that?
Yes, sir, Your Honor.
Now, the charge alleges, Mr. Howland, that on or about October 4, 2024 in Highland County, Ohio, you did knowingly obtain, possess, or use Schedule I controlled substance with heroin, an amount that equals or exceeds 1 gram is less than 5 grams, violation of Section 2925.11 of the High Revised Code. So that's the charge with the penalties I described. You understand what the state said you did, when, where, and how they alleged you did it?
Yes, sir, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defense you might try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, sir, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, sir, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there's a sentence, a little over one sentence in bold, an underline that reads as follows: defendant will enter a plea of guilty to the indictment, state defense will argue sentencing. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, do you hold any license or certification from any state and governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
Right, now, you have certain constitutional rights that you must understand before it can accept your plea. First, you have right to counsel. Mr. Wagner has been appointed to represent you. That wasn't simply to work the case out, but provide any defense that may be available to you that you would like him to provide. So if you decide that you do not want to do this, you will still have counsel represent you and defend you, including trial, if that is what you want. You understand that?
Yes, sir.
All right, now, you have a right to have a jury trial on this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and that jury of 12 would be instructed on the law. And then they would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney in open court. That means that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else who may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
And now under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a subpoena, and that's a court order, and that requires those people to come to court to be able to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir, Your Honor.
All right. Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence or to testify in this case at any time during the proceedings. In fact, no one's even allowed to talk about that if you decide not to testify. And if you do not testify at trial, then the judge does instruct the jury that because that's your right, the jury cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, you're presumed innocent under the Constitution of this charge until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof isn't on you to try to show that you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, burden of proof will remain upon the state to prove your guilt on every essential element of the offense charge by proof beyond a reasonable doubt, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, sir.
Now, originally, you entered a plea of not guilty, Mr. Howland. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. Change your plea from not guilty to guilty. That is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. That plea will waive or give up all the rights that I've described for you today, except your right to have an attorney. You will always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront the witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that is what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think you should have had up until this point in the case. Now, if I should sentence you the maximum sentence under other certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir, Your Honor.
And are you a U.S. citizen, Mr. Howland?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand those?
Yes.
Have any questions about your constitutional rights?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
I didn't mention this at the beginning, but if you have any questions with Mr. Wagner or anything you'd like to speak about with him about before we go any further, I can put the two of you in the breakout room. It'll be just the two of you on the screen. No one else will be able to see you or hear you. Do you need to speak with him about anything before we go any further?
No, sir, Your Honor.
You have any questions at all about what I've explained?
No, sir.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the agreement we just gone over?
Yes, sir, Your Honor.
Then as to the charge which alleges that on or about October 4, 2024 in Highland County, Ohio, who knowingly obtained, possessed, or used a Schedule I controlled substance with heroin in an amount that equals or exceeds 1 gram but less than 5 grams, violation of Section 2925.11A of the Ohio Revised Code, a fourth-degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000, and a license suspension from 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds that on this day in open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. Pleas accepted, order filed. Defendant is found guilty. Matter is referred to the probation department for a pre-sentence report. Sentencing will be on January the 8th at 9 a.m. and bond will be continued. Probation department, Ms. Sturgill's listening, so the probation department will be in touch with you to do your pre-sentence interview in preparation for your sentencing. That sentencing will be in person. All right, anything further from counsel?
No, Your Honor.
No, sir.
All right, is Mr. Crest on bond? He is, isn't he?
He
Yes.
posted, yes, sir.
All right, is he going probation, or is he going to be here in person, or what?
I think he's doing it by Zoom, Your Honor. We sent him the link yesterday when he came
Yeah.
in and signed the form.
All right, so is he going to be signed on from home or going to probation?
Should be from home, I believe. I just texted him, asking him where in the world he's at.
Well, Ms. Sturgill's shaking her head no.
He's supposed to be here.
All right.
Okay.
Okay, well, just sign in whenever he gets there, then we'll wait for that. So we got about 15 minutes.
Yes, sir.
All right, this is case number 24 CR 133, State of Ohio versus Preston Crest. Are you Preston Crest appearing there by on the screen marked iPhone 2?
Yes, sir.
All right. This is a plea hearing being conducted at the request of the parties. Mr. Wagner represents the defendants appearing from his office. Representing the state is Prosecuting Attorney Collins. Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are, sir. We spoke about it yesterday.
All right, you're okay with that, Mr. Crest?
Yes, sir.
All right, if at any time during the proceedings you need to speak with your attorney, since you're not seated next to him in the courtroom, just tell me. I'll put the two of you in a breakout room. It'll be just you and he on the screen. No one else will be able to see you or hear you, okay?
Yes, sir.
All right, now, the defendant is charged with a 4-count indictment plus a forfeiture specification, so 5 counts in all. Matter set for trial, I believe, on the 16th. Matter was scheduled today for a plea hearing last week, and I have a plea of guilty form here, Mr. Crest, that says you're going to plead guilty to counts 1 and 5. I'm going to hold the first page up to the camera and ask if you recognize that page. Has your case name and number and the plea of
Yes,
guilty
sir.
form. All right. Then on the 4th page of this document, the last sentence on that page reads, "I enter this plea voluntarily." Right below there appears to be the signature of, it looks like J. Preston Crest. Is your first initial J?
No, my lawyer accidentally about signed it, and then
Oh,
I
that's
signed
his
it.
J. Oh, okay.
That was my fault, Your Honor. I
Okay.
signed the wrong line.
All
I
right,
stopped
so I'm going to
mid-sign.
hold that up there, and is that your signature next to the J?
Yes, sir.
All right, and you signed this when?
Yesterday morning.
All right, now when you signed it, did you understand it was a plea agreement, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Absolutely, Your Honor.
And you went over this with your attorney and had him explain everything to you before you signed it?
Yes, sir.
And you think you had enough time to fully consider the matter before making that decision to sign it?
Absolutely.
And did you sign this agreement voluntarily?
Yes, sir.
Are you going forward today with your plea voluntarily?
Yes, sir.
All right, so on page 1, it says you're pleading guilty to count 1, trafficking in a fentanyl-related compound under 2925.03A2 of the revised code, a first-degree felony, and forfeiture specification under 2941.14.17 under count 5. Now, states on page 1, you understand that as to count 1, you could receive a sentence of between 3 and 11 years as a minimum set by the judge, and that is a mandatory sentence that must be served. And then it could be extended by a period of up to 1/2 to a total of 11 years by the Department of Corrections. There could be a fine of $20,000. There is a mandatory fine of $10,000, and there's a license suspension of 6 months to 5 years. Do you understand that?
Yes, Your Honor.
Now, with regard to count 5, that would just result in the loss of the property that's referred to in that count to the state. You understand that?
Yes, Your Honor.
All right. Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on community control, probation, parole, or post-release control for a felony?
No, Your Honor.
All right. Now, as I indicated to you in this charge, whatever sentence the court sets is a mandatory minimum sentence. So we'll use the example of worst case scenario. Let's assume that you got 11 years. That would be a mandatory sentence. You would have to serve that. At the end of that 11 years, there's a presumption that you should be released. However, the Department of Rehabilitation and Corrections could overcome that presumption by making specific determinations that your conduct while confined and your rehabilitation and your any threat to society and the need for restrictive housing while you were confined and your security classification, they would consider all of those determinations or all those things. And if they make the determinations, then they could continue you for a period of up to 1/2 of the prison term. And so that is 11 years, so that means it could be 5.5 more years. So that means that potentially, under the law, if you got the worst sentence possible, 11 years, high sentence, I should say, it could be 16 and a half years. Now, if you got the minimum sentence of 3 years, then half of that is 1.5 years. So that means a 3-year sentence by the court would potentially be a 4.5-year sentence after you serve the 3. And if you received the 11-year mandatory, could be a maximum of 16 and a half. All right. So, do you understand all that?
Yes, Your Honor.
Okay. Now, under the law, once you are released from prison, it is mandatory that you be supervised under post-release control for a period of at least 2 years. It could be up to 5 years, and that would be by the Department of Rehabilitation, by the Adult Parole Authority. Department of Rehabilitation Corrections makes the decision on whether to extend the sentence under the law, but once you're released, it's the APA that supervises you, and you would be supervised under the terms they set. And if they determine that you had not complied, they could return you to prison as a sanction to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if you were convicted of a new felony while under post-release control and sentenced to prison, that prison term would have to be served consecutively to any prison term imposed for committing that offense while under post-release control in this case. Do you understand that?
Yes, Your Honor.
Okay. And on your plea form, the provision about community control or probation is marked out because, again, just to make sure you understand, you're not eligible for community control, probation, or judicial release or anything on your minimum sentence. You understand that?
Yes, Your Honor.
All right. Now, the charge in count 1 alleges that on or about July 8, 2024 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound, a Schedule II controlled substance, in an amount that equals or exceeds 200 unit doses but is less than 500 unit doses, or exceeds 20 grams but is less than 50 grams, when you knew or had reasonable cause to believe that it was intended for sale or resale by the offender yourself or another, in violation of Section 2925.03A2. So that's the first-degree felony of trafficking in a fentanyl-related compound. Count 5 is the forfeiture, and it alleges that on or about July 8, 2024 in this county, you had in your possession $22,305 in U.S. property subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in ORC 2941.14.17. And that would result in the loss of that to the state. Now, do you understand what it is you're charged with in each of those counts, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
Do you understand the penalties for each?
Yes, Your Honor.
Have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Absolutely, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to make you plead guilty here today?
No, Your Honor.
Now, at the bottom of page 2 and running on to page 3, there are some lines in this document that are printed in bold and underlined, and I will read those at this time. Defendant shall enter a plea of guilty to count 1 and count 5. State will dismiss remaining counts. State and defense jointly recommend 5 years mandatory incarceration. Defendant agrees to the forfeiture outlined in count 5. State will not pursue charges from the events of September 11, 2024. Is that your understanding of the agreement?
Yes, Your Honor.
And has anyone promised you anything other than that to get you to plead guilty?
No, Your Honor.
Now, under the law, Mr. Crest, the matter of sentence is up to the court, not to the parties. And so even though there's an agreement, you should get a 5-year sentence. If you plead guilty, I'm not bound by that agreement. I could, after hearing all the information presented, sentence you to any sentence between 3 and 11 years that I think is appropriate under the law and the facts of the case. You understand that?
Yes, I do, Your Honor.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
All right. It'd be something like a vet tech or pharmacy tech or nursing assistant, things like that. Okay. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have right to counsel, and Mr. Wagner was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law. So, in the event that you decide you don't want to plead guilty, then he will continue to defend you and represent you, and including a trial, which we have set for the 16th, if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those individuals are selected, the evidence will be presented, they'd be instructed on the law. And then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt on either or both counts. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, the right to have a jury trial, and in that case you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Crest, you have a right to confront witnesses against you and to cross-examine them in open court through your attorney. What that means is witnesses against you have to come into court and testify in public in front of you and your attorney and anyone else may be present. After the prosecutor's done asking questions, your attorney asks questions, which is called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's a summons or a subpoena. And that forces those people to come to court to be able to testify if you want them to, even though they don't want to be present or participate at all, which is the same way the state's witnesses are forced to testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you decide you're not going to testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty, Mr. Crest. That plea denied the allegation of the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. If you change that plea today from not guilty to counts 1 and 5, that is the opposite of the not guilty plea. The guilty plea will admit the allegations in each count, admits that it's a crime, and that you committed that crime. And that plea would waive or give up all of the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or a court trial. It waives, gives up your right to confront the witnesses against you in open court and to cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It waives, gives up your presumption of innocence, because if you say, waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. Waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. So it waives those rights as well as the other rights I've described, except your right to have counsel. You understand all that?
Yes, Your Honor.
Okay. Plea of guilty would subject you to being sentenced immediately by the court, although that's not what I'm going to do today based on the agreement, it looks like. And it would waive or give up any right to file an appeal on any alleged violation of your rights you feel could have occurred up until this point. Now, if I should sentence you to the maximum sentence, or under other limited circumstances, an appeal could be filed, but it would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor.
And you are a U.S. citizen, Mr. Crest?
Yes, Your Honor.
Do you have any questions about the two charges or the penalties associated with them?
No, Your Honor.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
No, Your Honor.
And you understand it?
Yeah.
And you understand the recommendation on sentencing is not binding on the court?
Yes, Your Honor.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, and what will happen if that plea is entered here today?
No, Your Honor.
Okay. Do you need to speak with your attorney about anything that we've gone over here this morning?
No, Your Honor.
You have any questions at all?
No, Your Honor.
Then it's your decision to go forward with the plea agreement and plead guilty to counts 1 and 5, according to the agreement that we've gone over.
Yes, Your Honor.
All right, then as to the charge in count 1, the alleges in on or about July 8, 2024 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound, a Schedule II controlled substance, an amount that equals or exceeds 200 unit doses but is less than 500 unit doses, or equals or exceeds 20 grams but is less than 50 grams, when you knew or had reasonable cause to believe the controlled substance was intended for sale or resale by the offender or another in violation of 2925.03A2, the offense of trafficking in a fentanyl-related compound under 2925.03A2, a first-degree felony, carrying a mandatory prison sentence as a minimum set by the judge of between 3 and 11 years with potential for that to be extended by up to 1/2 of the mandatory sentence, a fine of $20,000, a mandatory fine of $10,000, and a possible license suspension for 6 months to 5 years. How do you plead?
Guilty.
Then as to the charge in count 5, which alleges that on or about July 8, 2024 in Highland County, Ohio, you had in your possession $22,305 U.S. currency, and the property is subject to forfeiture due to its instrumentality. The commission for facilitation of the offense is defined in ORC 2941.14.17, which would result in loss of property to the state. How do you plead?
Guilty.
All right, thank you. Court finds on this date, open court, defendants advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Pleas or accepted order filed. Defendants found guilty of counts 1 and 5. Counts 2 and 4 are dismissed. Court will order that sentencing take place on January the 8th at 9 a.m. That will be in person. Your report here no later than 9 a.m. So your bond is continued. You're still under the same bond conditions. If you don't show up, Mr. Crest, that means that there's much less likely that the court will follow the recommended sentence. So it also could result in you being prosecuted for an additional felony of failure to appear. So you need to make sure you're present. So continue to report to probation as they direct, and be here at 9 a.m. on January the 8th. All right, is there anything further from counsel?
No, sir.
All right, thank you.
Thank you, Your Honor.
Actually, that's it on this invitation, I believe. Yeah, okay.
Thank you.
Case number 24-0175, State of Ohio versus Donald Morris. Present for the state is Prosecuting Attorney Collins. Present for the defendants, Attorney William Armitrout. And are you Donald Morris?
Yes, sir.
All right. And Mr. Armitrout, are you retained in this case?
Yes, sir.
Okay. All right. Court has before it a proposed bill of information and a waiver of indictment. As well as a plea agreement. And what I'm looking at here, Mr. Morris, we'll look at the plea agreement first. And the case is 24-0175, by the way. It's proposed that you're going to enter a plea guilty to having a weapon under disability, illegal cultivation of marijuana, and a forfeiture. Then counts 1 and 2 are felonies, and then count 3 is a results in the loss of property to the state. Now, under Ohio law, no person can be required to appear before this court to answer to a felony charge until and unless that person's case has been considered by the grand jury and an indictment returned. The grand jury is a group of 9 people that live in Hineley County that meet once a month usually, and they consider evidence presented to them by the prosecutor concerning alleged crimes. The grand jury does not make a determination on whether a person is guilty or not guilty. They simply decide whether there's enough evidence to warrant the case going forward for prosecution. And so therefore, only 7 of the 9 have to vote to return an indictment. Now, once that is done, that the indictment is the paper charge that lists the charges. And then that person comes before the court, generally enters a not guilty plea, the matter's then set for schedule, and proceedings occur. So that hasn't happened in your case yet. Now, you can, however, under the law, waive your right to have your case considered by the grand jury to return an indictment. That's called a waiver of indictment, and I have that form here. And it indicates that you've signed that on the 4th of November. Is that correct?
Yes, sir.
All right, and it says that you understood that you have the right to be prosecuted by way of indictment, and that while you're being represented by Mr. Armitrout, you're voluntarily waiving that.
Yes, sir.
All right. So what that means is if you waive the right to have the grand jury return an indictment, then the case is prosecuted by what's called an information. An information is basically the same thing as an indictment. It is a paper that says these are the charges and they list them. And so that's what this bill of information is. Now, in this case, the count 1 alleges that on or about July 23rd of this year in this county, that not having been relieved from a disability as provided by a revised code 2923.14, you knowingly acquired, had, carried, or used a firearm as defined under the statute, and it lists several firearms there due to your having previously been convicted of an offense of violence, which would be failure to comply with the order signaled police officer back on February 3rd of 2016. And then count 2 alleges that on or about that same date, you knowingly cultivated marijuana in an amount equal to or exceeding 200 grams but less than 1,000 grams. And so those are the 2 felony charges. And then count 3 alleges that you had, looks like 4 firearms there that are subject to forfeiture because they were the items that are used to facilitate the offense, because in order to be guilty of offense of weapon under disability, you have to have weapons, and so those are the items. And so that's the 3rd charge. And Mr. Armitrout, how long have you had a copy of this bill of information? More than
Sometime
20?
prior to November 4th, Your Honor.
Okay, more than 24 hours?
Yes.
Okay, all right. So those are the charges that are to be considered. So if you are agreeing to go forward by waiving your right to have the grand jury consider it, these are the 3 charges then. So is that what you want to do?
Yes, sir.
Okay. All right. Now, plea of guilty form is 3 pages, I believe. And it states that you're going to plead guilty to count 1, 2, and 3, the 3 I just read to you. And on page 3, there's a line at the end of the text that reads, I enter this plea voluntarily. Right below that appears the signature Donald G. Morrison. Is that your signature I'm looking at?
Yes, sir.
Do you remember when you signed this, Mr. Morrison?
Yes, sir.
When was it?
November the 4th, I believe.
Oh, okay, all right. So it's been some time, it's been over a month. Have you had any change of mind?
No, sir.
This is still what you want to do?
Yes, sir.
And you did that voluntarily then, and you want to go forward voluntarily today,
Yes, sir.
all right? Now, the agreement then, as I indicated, is you plead guilty to the 3 counts I read, counts 1, 2, and 3. You understand that count 1, the weapon under disability, is a third-degree felony that has a possible term of imprisonment of between 9 and 36 months and a fine of $10,000. Count 2, the illegal cultivation is a fifth-degree felony, has a possible sentence of 6 to 12 months and a fine of $2,500 and a potential license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, if you are sentenced to prison for these offenses, they could be ordered to be served consecutively, meaning one after the other. You understand that?
Yes, sir.
Now, other than these charges, Mr. Morris, are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
All right. Now, under the law, if you are convicted of this offense, it is possible that the Adult Parole Authority, upon completion of the prison term, would impose a period of post-release control, which means that you would be supervised by a parole officer for a period of up to 2 years on the terms they set. And if during that period of time they determine never mind, that's not what I need. They determine that you have failed to comply, then they could return you to prison to make you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term for all violations. However, if you committed a new felony while under post-release control, then the judge in that case could sentence you for committing that felony offense while under post-release control, in this case, to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, the court is not required to sentence you to prison. I can't impose what's called community control or non-prison sanctions, meaning that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. Just a second here, I'm going to let me know. Mr. Johnson's going to be about 5 or 6 minutes. I'm just finishing up the plea here. Okay. And so if that could be for 5 years under the term set by the court, and if during the period of time you're being supervised, the probation department thought you were not compliant, they would file a written notice of that with the court. There would be a hearing, you'd get a copy of it, you'd have a right to have an attorney. At the completion of that hearing, if the outcome was that you had failed to comply, then the court could revoke your community control and sentence you to a total of 48 months incarceration and fine you $7,500 total based on the 2 charges. And if you were convicted of another felony offense that caused you to be terminated from community control and were sentenced to a term of incarceration, in that case, that could also be served consecutively to the sentences in this case. Do you understand that?
Yes, sir.
Now, I read the charge to you there a minute ago, but I'll read it. I've already read it, so I'm going to ask you, do you recall what it is you're charged with in each of these 3 counts, what the state said you did, when, where, how, they alleged you did it?
Yes, sir.
And you've discussed the nature of those charges and the evidence in the case, and possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Absolutely.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
Now, the second page has 2 lines that are printed bold and underlined that read as follows. Defendant shall enter plea of guilty to the bill of information. State and defense jointly recommend community control. Defendant agrees to forfeiture specification. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is not up to the parties is up to the court. So in the event you plead guilty, the court does not have to give you community control. After considering everything, the court could decide that's not correct under the law. The evidence and could sentence you to a term of incarceration of up to 48 months and fine you $7,500. You understand that?
Yes, sir.
All right. The sheriff hasn't signed it yet, so tell him we'll be ready in about 5 minutes. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
All right, now you have certain constitutional rights, you must understand, before I can accept your plea. First, you have a right to have an attorney, and Mr. Armstrong has been employed to represent you. In the event that you do not have the money to hire an attorney or to continue to pay him, then the court would appoint an attorney for you. So you understand that?
Yes, sir.
All right, so you're not entering into this agreement because of a concern about being able to pay for an attorney?
No, sir.
All right, now, you have the right to have a jury trial on these charges in which 12 people would be selected from a group of citizens that live in Highland County that are selected for jury duty on your trial date. After they are selected, the evidence will be presented, and then they would be instructed on the law by the court. And that jury of 12 persons would have to decide by unanimous verdict whether or not the state proved your guilt. Now, if you did want to have a jury trial, but you did want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. That means instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have the right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court will issue a court order, it's called a subpoena, and that would force those witnesses to come to court to be available to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this case at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in proceedings, and in fact, no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't upon you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. But whether you do or not, the state of Ohio will be required to prove your guilt on every element of each of these three offenses by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right. Now, originally, since this is your first appearance, you have the opportunity to enter a plea of not guilty. Not guilty plea denies the allegations in the bill of information, denies you committed a crime, and would exercise all the rights I just described. If you change, or if you enter a plea instead of guilty, as is proposed, that is the opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits you committed a crime, and it exercises or invokes all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you, cross-examine through your attorney, will waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your own behalf. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, a wage goes up in right to file an appeal you think you may have had. If I do sentence you to a maximum sentence, or under the certain circumstances, you could appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
Are you a U.S. citizen, Mr. Morris?
Yes, sir.
All right. Now, do you have any questions about the bill of information or the process that's bringing you before the court?
No, sir.
You understand it?
Yes, sir.
Have any questions about the charges?
No,
or the
sir.
penalties? You understand those?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand that?
Yep.
And again, you understand the recommendation on sentencing is not binding on the court.
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
Anything you need to speak with your attorney about before we go any further?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the 3 charges in the bill according to the plea agreement that we've just gone through?
Yes, sir.
Is that your decision?
Yes, sir.
And you're doing that voluntarily?
Yes, sir.
So, as to count 1, it reads that on or about July 23, 2024 in Highland County, Ohio, that you, not having been relieved from a disability as provided in the Ohio Revised Code 2923.14, did knowingly acquire, have, carry, or use a firearm as defined in ORC Section 2923.11b1, to wit, a Remington 870 12-gauge shotgun with a serial number, double-barrel shotgun with serial number unknown, Mossberg 410 bolt action, a 183C shotgun, a Marlin 22 caliber Model 60 with a serial number, and that you had previously been convicted of a felony offense of violence, to wit, failure to comply with the order of signal police officer in violation of Section 2921.331B of the Ohio Revised Code, a felony of the 3rd degree in Highland County Common Pleas Court case number 15 CR 273 on February 3, 2016, in violation of 2923.13A2, which is the offense of having a weapon under disability, the 3rd degree felony with the penalties I've just described. How do you plead?
Guilty.
As to count 2, which alleges on or about July 23, 2024 in Highland County, Ohio, did knowingly cultivate marijuana, a Schedule 1 controlled substance, to wit, in amount equal to or exceeding 200 grams, less than 1,000 grams, in violation of 2925.04 of the Ohio Revised Code. 5th degree felony with the penalties I described previously. How do you plead?
Guilty.
Then as to count 3, the alleged on or about July 23, 2024 in Highland County, Ohio, he had in your possession items subject to forfeiture due to their instrumentality in the commission or facilitation of the offense as defined in ORC 2941.14.17, a Remington 870 12-gauge, double-barrel shotgun, serial number unknown, a Mossberg 410, bolt action 183DC shotgun, and a Marlin 22 caliber Model 60, which would subject those items to the forfeiture to the state. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, the court finds on this day in open court, defendants advised of all his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendants found guilty of all 3 counts. Court orders a pre-sentence report be conducted, and that shall include an assessment for substance use and or mental health issues. Sentencing will be set for January the 8th at 9 a.m. That'll be in person. The court is ordering that bond be OR only, which means that you're going to sign a bond downstairs and promise to appear. If you fail to appear, you can be prosecuted for an additional felony. Be required to pay a service fee deposit of $116 for the statutorily required fees. You'll be under pretrial supervision of the Probation Department, 117 East Main Street. You need to report to them immediately after court. Let them know you entered a plea of guilty to a bill. They'll set up your supervision as well as your PSI interview. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home cell employer. If recommended by probation, you'll be evaluated for substance abuse and mental health issues. Any treatments indicated, enroll and follow that area of this case. You'll be under house arrest at your residence unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with attorney, probation officer in this or any other case, and can can also go to any kind of educational programming, church services, and holiday family events during the holiday. And also, after you go to the probation department, you'll need to report to the sheriff to be fingerprinted and booked on this charge. All right, anything further from council?
No, Your
No, Your
Honor.
Honor.
All right, see the bailiff, you're going to sign your assignment notice with your court date, go to the clerk's office to sign your OR bond, and then down to the probation department, then to the sheriff. Okay, thank you.
Thank you.
You got that?
All right. All right, this is case number 24 CR 162, State of Ohio versus Jared Wayne Mick. Are you Jared Wayne Mick appearing there from the jail?
Yes.
All right. Now, this is an arraignment on an indictment. Mr. Mick was indicted for assault and strangulation. His attorney, being conducted by Zoom, his attorney is Caleb Johnson of Washington Courthouse, Ohio. You've been retained, Mr. Johnson?
Yes, Your Honor.
All right. Prosecuting Attorney Collins is appearing on behalf of the state from her office, and Mr. Johnson is appearing from his office. Ms. Collins, has the alleged victim or victims of the offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
They have been advised of the hearing, and they will not be attending.
All right. All right, now, Mr. Mick was indicted for assault under 2903.13a, a fifth-degree felony, and strangulation under 2903.18b3, the Ohio Revised Code, a fifth-degree felony. Mr. Johnson, I believe your client was served with a copy of the indictment more than 24 hours prior to today's hearing. Is that correct?
Correct.
All right. Do you wish to have the indictment read?
No, Your Honor.
All right. And how does your client plead?
Your Honor, we did also submit a written notice of not guilty by reason of insanity.
Okay.
We did that yesterday.
All right. Let me look here. Yeah. I don't have that. The last thing I have is a notice of appearance, demand for discovery, filed on the 3rd. So it just hasn't made it up yet. But you entered an NGRI, you say?
Yes.
All right.
And I did, Your Honor, I did also, of course, with a request for a examination to be conducted on the NGRI portion. I also did ask for a competency eval for now as well.
Okay.
Yes.
All right. Actually, I look now. I just didn't check the red sleeves, but I did find your plea of not guilty by reason of insanity and motion to determine competency for evaluations. All right. Okay. Well, with that said, then the court, I won't issue the normal scheduling order. I'm going to go ahead and note in here in the arraignment entry that a motion or a plea of NGRI was issued or was filed, and a request for competency. And so under the statute that will toll the speedy trial time, so we will not set anything until we have those reports back. I'll order those reports be done by the Forensic Evaluation Center out of Hamilton, Ohio. Mr. Mick, the psychologist, will be in touch with you. They'll come to the jail or perhaps do it by Zoom. I think they prefer to come, and I'd prefer them to come. Sometimes they do it by Zoom if they're really having a logistical issue getting there. But as soon as they get there, we'll get their report. I will set the matter for a hearing on competency just to give them a target date. I usually give them 30 days. So today is the 10th. So, but I'm probably need to give them a little bit more because of the holidays. So, Mr. Johnson, you have your calendar there.
Yes, Your Honor.
Let's see here. How about the 15th of January? You have any time in the afternoon?
Let's see. I could do, the only thing I could do would be Zoom in the afternoon.
That would be all right. We can do it by Zoom if that's all right with you and your client.
All right.
All right, let's set it at 1 o'clock.
That works.
And again, if we don't have the report back, we'll notify you, but I found that it works better if I give them a deadline. That gives them something to shoot at and puts us in a priority. Huh? Oh, okay. Now the bailiff's responding to some sort of an emergency somewhere. Hopefully it's downstairs and not in DR court. All right. Now, state wish to be heard on the matter of bond?
At the current bond is, or we requested a bond of $10,000. We would ask that that bond be instituted. We would note that this is, while only alleged offenses are felony offenses of violence, the defendant's criminal history is minimal, but it does include public indecency. Based on the nature of these offenses and the threat that he does pose to the public, we would ask the court to issue a $10,000 bond in this.
Mr. Johnson?
No objection, Your Honor.
All right. All right, so the bond will be set in the amount of $10,000 plus your own recognizance, Mr. Mick, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. If you also be required, in order to be released, to pay a fee of $116 as a deposit for certain constitutionally required fees, or statutory required fees, I should say. And if you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. Report to them immediately after court. Report once a week for 4 weeks. After that, as they determine, undergo random drug testing. Provide phone numbers for home, cell, employer. Have no contact with the alleged victims. If recommended by probation to be evaluated for substance abuse or mental health issues, if any treatment's indicated, you're to roll in and follow that during the period of this action and be under house arrest at your residence. Meaning you have to be there all times unless you're working, going to and from work. Medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, attend any kind of job training, schooling, educational programming, and church services, and if you're out for the holidays, you can attend family holiday events. If you fail to comply with that bond order, then that could be revoked. You could be taken back into custody and held until the court determines an appropriate bond. All right, is there anything further from counsel?
No, Your Honor.
All right. We're ready for the bail review hearings there, Deputy.
Let's continue with the same Zoom, Your Honor, or lose it and the other link.
Yeah, we're doing the same link.
Okay.
JD said he's having issues logging in.
Step on
Are
that.
you sure you gave this link?
Yes.
That's a separate link.
Oh, the bail review is? Oh, Deputy,
Yes, sir.
I'm standing corrected. Ben issued a separate link, so we're going to all have to sign off and start over. I'm sorry.
Yes, sir. We'll
Yeah.
do that. We'll be right back on.
Okay. That's where the deputies are. There we go, or the attorneys are there. What was the red light about?
They're testing.
Testing the system.
Why did we get a red light for testing?
We're on the record right now, I think.
Yeah, oh.
We got a
All right, he's there. All right, are you Kenneth Skags appearing there from the jail?
Yes, sir.
All right, there are two cases here before the court in which Mr. Skaggs is the defendant. Case number 20 CR 239, which is a charge of theft and vandalism, and case number 22 CR 15, which is a charge of failure to comply with the order signal of a police officer. Defendant's appearing by video from the Sheriff's Department. and is represented by Attorney Dennis Kirk, who's there with him. Prosecutor Collins is representing the state. Mrs. Collins, with regard to 20 CR 239, have the alleged victim or victims of the offense been notified of the time, place, and purpose of this hearing, the right to be heard?
An email was sent to the representative at South Central and to the commissioners advising them of the bond review hearing.
Okay. All right. So this is a bond review hearing. Bond was set when Mr. Skags was arraigned last Friday, I believe it was, in the absence of counsel. And so pursuant to statute, the court is conducting this review within 48 or 2 business days. Mr. Kirk, anything you'd like to say regarding the matter of bond?
Thank you, Your Honor. My client is unable to post the current bond, would ask the court to reconsider the bond and consider a reduction in bond. He does have a Bainbridge, Ohio address to go to, and has advised me he would report to probation immediately.
Ms. Collins?
Your Honor, I would ask that no bond reduction be granted in this case. I would note that in the 20 case, we've been looking for the defendant for 4 years. In the 22 case, he outran the officer and has had a warrant for his arrest for over 2 years. I've also learned very recently that he has another failure to comply by the Hillsborough Police Department that will likely be presented to grand jury, in which he ran from officers, and due to the safety of the community, the officer had to stop the chase. There's no false belief here from anybody in law enforcement that Mr. Skags will not take off again, and we will have to look for him and chase him if he is given a bond any lower.
Well, based on the fact that it's been 4 years in the 20 CR 239 case and 2 years in the 22 CR 15, and it involved a fleeing and eluding, due to the nature of the offenses, the alleged behavior of the defendant, as well as the safety of the public, the court feels that it's necessary for the bond to remain the same. So it will remain the same. All right. Thank you. Could I have Stacy Ficker, please?
Yes, sir.
Yeah, I'm covered for Danielle on that one, yeah.
Morning, Mr. Skaggs.
I'll be back up to see you, okay?
Not seen that before. All right, case number 24 CR 170, State of Ohio versus Stacy Ficker. Are you Stacy Ficker appearing there from the jail?
Yes, sir.
All right, Ms. Thacker's attorney is Danielle Witt. She called this morning. She was unable to be here. She's in another county, and Mr. Kirk, Dennis Kirk, has agreed to stand in for her for this bond review hearing. The state is represented by Prosecutor Collins. The defendant was arraigned last Friday on charges of aggravated possession and aggravated trafficking of methamphetamine, both second-degree felonies, and bond was set in the absence of counsel. Counsel was appointed at that hearing, and so pursuant to the statute, the court is conducting this review. Ms. Collins, anything, or I'm sorry, Mr. Kirk, anything on behalf of the defendant?
Thank you, Your Honor. My client, or Ms. Witt's client's unable to make the current bond. Discussed with her that Ms. Witt will be representing her, so if there's any type of motion based on any new information about a bond reduction, I'm sure she'll file it at that time.
All right, Ms. Collins.
Your Honor, we would ask the bond remain in place. Would note the nature of these charges. These are mandatory. These charges do carry mandatory prison time. Would also note that the defendant has previously had a warrant placed for her arrest for failure to appear. So based on that, we would ask the court to leave the bond in place.
All right, well, the court will note that according to the Ohio Court Network report, which we get for all arraignments, Defendant had a failure to appear on 9/2/14, which appears to be out of Hillsborough Municipal Court, and then another one on May 2nd, 15, appears to be out of Brown County. So based on the fact that these are mandatory sentencing charges if convicted, in that history, the court will leave bond the same. And we notified your attorney of her appointment, Ms. Thacker, and she'll be in touch with you. All right, thank you. All right, Mr. Belisle.
Not hearing this.
All right, are you Gene M. Belisle appearing there from the jail?
Yes, sir.
All right, this is case number 24 CR 172, State of Ohio versus Gene Michael Belisle. Mr. Belisle is appearing from the jail as indicated on a Zoom hearing for a review of bail that was set in the absence of counsel last Friday. And so pursuant to statute, the court's conducting the review at this time. His attorney is Jacob Wagner, appearing from his office. Appearing from the representative prosecutor's office is Prosecutor Annika Collins. Ms. Collins has either the victim or the alleged victim or a representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be heard?
We have attempted to notify her of the hearing.
All right. All right. Mr. Wagner? You're muted, Mr. Wagner. You're muted.
Sorry, Your Honor. I'm remotely aware of a little bit of the facts of this case, Your Honor. Obviously, don't have full discovery in yet. Understand the charges, so I know the bond will be high. Respectfully, Your Honor, whatever bond the court sets, I don't believe my client will be able to make it. We would just ask that it be a reasonable bond, sir.
Mr. Collins?
Your Honor, we would ask the bond to remain in place. We would note the defendant does have a prior criminal history. He has no ties to Highland County. He lives in Kentucky. He was on parole in Kentucky. He was picked up in Kentucky and brought back to Highland County. So he obviously, based on the nature of these charges, would have a reason not to return to Highland County. And with the fact that he has no ties to Highland County, that would increase. This bond is also necessary for the protection of the public. Obviously, the nature of these crimes are very, very serious. While only allegations at this point, they are very serious allegations.
You say he was picked up on a parole violation. Would it be from the state of Kentucky or Ohio?
He wasn't picked up on a parole violation. He's on parole.
He was on parole.
He's on parole in Kentucky, reported to his parole officer. We had already contacted him and told them that we were issuing a warrant for his arrest based on the charges. And when he came in to report, they arrested him.
And what was that charge, do you know?
That he's on parole for down there.
Yeah.
I want to, maybe a gun charge, maybe a weapons under disability. I'm not for sure,
All right.
honestly.
Of a handgun.
I'm sorry?
There's a possession of a handgun.
Okay.
Convicted felon.
All right.
Probation.
All right. All right. Well, based upon the nature of the charge and the out-of-state situation, the court feels that bond will need to be the same. Now, it could be subject to review if Mr. Wagner, you have some specific conditions that might meet the court's needs, including keeping him in a state of Ohio. So if something like that comes up, the court would reconsider it, but it'd still be a substantial bond, but I would consider reducing it. But
Yes, sir.
okay. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
That's it, right?
Yes, Your Honor.
All right, are you Robbie L. Mion appearing from the jail? Oops. Are you Robbie L. Mion appearing there from the jail?
Yes, sir.
All right, this is case number 24 CR 130. State of Ohio versus Robbie L. Mion. This is a plea hearing being conducted by Zoom. Mr. Mion is represented by Dennis Kirk, appearing from his office, representing the state, Assistant Prosecutor King. And Mr. Kirk, are you and your client both in agreement that this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, Your Honor.
You all right with that, Mr. Mion?
Yes, sir.
All right, if at any time during the hearing you would like to talk to Mr. Kirk, just tell me. I can put the two of you in a breakout room. It'll be just you and him on the screen. No one else will be able to see you or hear you on the computer, and the deputy will step out and shut the door while that's going on, so it'll be confidential, a conference, okay?
Thank you.
All right. Now, Mr. Mion, you're charged in a three-count indictment. Count 1 is aggravated trafficking, and count 2 is aggravated possession of methamphetamine. 2 third-degree felonies, plus there's a forfeiture specification. Now, the court has received a plea of guilty form, which indicates you're going to plead guilty to count 2 of the indictment. Now, I'm going to hold this up to the first page of this up to the camera. Has your name and guilty plea case number on that?
Yeah.
You recognize that document?
Yes, sir.
All right, and on page 3, there's a signature line below a sentence that reads, "I enter this plea voluntarily," and it looks like below that is the signature Robbie Mion. I'll hold that up there and ask if that's your signature. When did you sign this, Mr. Mion?
Last week.
All right. When you signed it, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did you go over this with your attorney and have him explain it and answer any questions you had before you signed it?
Yeah, we went over it.
And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
And you have had a few days since you signed it to reconsider. You haven't changed your mind. You still want to go forward.
Yes.
And you're doing that voluntarily?
I am.
All right. Now, the agreement states that you're going to plead guilty to count 2, the aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code of third-degree felony. Further states that the maximum the penalties possible for that are between 9 and 36 months, fine of $10,000, and there's a license suspension of 6 months to 5 years as possible. Prison term is presumed to be required, although it's not necessary, but it's not required. You understand that?
Yes, Your Honor.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you serve a prison term, once you complete that prison term, it is possible the Adult Parole Authority may put you on what's called post-release control for a period of up to 2 years. That means that you'll be supervised under the terms that the Adult Parole Authority sets by a parole officer, and if during that period of time they feel or they find that you have failed to comply, they could return you to prison to make you serve an additional sanction for that violation of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony and are convicted and sentenced to prison on that, then the judge in that case could sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Right now, the charge in the case alleges that on or about April 15, 2024 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit methamphetamine, an amount that equals or exceeds bulk amount but is less than 5 times bulk amount. And so that's the charge of the third-degree felony that I just explained to you, the possible sentences for that. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes. Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
I have.
Are you satisfied with his advice and confidence in this matter?
Yes, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there are a couple of lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 2. State will dismiss remaining counts. State defense jointly recommend 18 months incarceration. Is that your understanding of the agreement?
Yes, it was.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
Right now, you have certain constitutional rights you need to understand before I can accept your plea. First of all, you have a right to counsel, and I appointed Mr. Kirk to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you'd like him to provide. So if you decide you do not want to do this, that you want to defend against the charge, he'll continue to represent you, including trial, if that's what you want. Do you understand that?
Yes, sir.
All right, now, Mr. Mion, under the Constitution, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Once they are selected, the evidence be presented. They would then be instructed on the law by the judge, and then that jury would have to decide by unanimous verdict, meaning all 12 have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Mion, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney has a right to ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
I do.
Now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order. It's called a subpoena, and that would force those witnesses to come to court to be able to testify if you wanted them to, even though they don't want to be there, which is the same way the state's witnesses are forced to come to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
I do.
Now, under the Constitution, Mr. Mion, you're presumed innocent of the charge till proven guilty by the state of Ohio and every essential element of the offense charge. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof at trial will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense, which is the highest burden of proof that's known under the law. Do you understand that?
I do.
Right now, Mr. Mion, originally you pled not guilty, which denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. You change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, and that you're the one who committed that crime. And that plea will waive or give up all of the rights that I've described for you today, except your right to have counsel. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine them through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state, would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjects you to being sentenced immediately by the court. And finally, waives gives up any right to appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other certain circumstances, you could file an appeal. Any appeal that you would file would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I do, sir.
And are you a U.S. citizen?
I am.
Now, do you have any questions about the charge in count 2 or the possible penalty?
No, sir.
You understand?
Yep.
You have any questions about the plea agreement?
No, sir.
You understand it?
I do.
Any questions about the plea of, or your constitutional rights that I've explained?
I do not, sir.
You understand them?
Yes, sir.
Any questions about the plea of guilty, what it means, and what will happen if you enter that pier today?
No, I don't think so. I understand.
All right, is there anything you need to speak with Mr. Kirk about before we go any further?
No, sir.
Then is it your decision to go ahead and plead guilty to count 2 pursuant to the terms of this plea agreement?
It is, Your Honor.
All right, then as to the charge in count 2, which alleges on or about April 15, 2024 in Highland County, Ohio, you knowingly obtained, possessed, or used Schedule 2 controlled substance, to wit methamphetamine, in an amount that equals or exceeds bulk amount is less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, a third-degree felony, carrying possible prison term between 9 and 36 months, fine of $10,000, a mandatory fine of, there is no mandatory fine, I'm sorry, and a license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right. Court finds on this day in open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Pleas accepted, ordered, filed. Defendants found guilty of count 2. Count 1 and 3 are dismissed. I did look at the discovery. I see here that the defendant does have a number of previous convictions and prison sentences, and so I don't think there's no request for PSI, so I'm going to go ahead and proceed with the sentencing. Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
Okay. Mr. Kirk?
Thank you, Your Honor. Would ask court to follow the plea agreement. 18 months would be a mid-range sentence and would be pretty consistent with other similarly situated defendants. And he's owned up to the possession charge, and so would ask the court to grant the plea as their sentence as the plea agreement.
All right, Mr. Mion, anything you'd like to say?
No, sir.
Have you got the jail time credit there? All right, it looks like you're arrested. It looks like you're arrested back September, but you served some time from 9/30 until 10/7 on a county court case. So looks like your time has run since October the 7th. So I'm going to check that calculation, make sure that's right. Okay, so that as of today, 23 and 30 and 10, 63. Okay, yeah. All right. It's a judgment order of the court. The defendant being is hereby sentenced to the Correctional Reception Center in Orion, Ohio for a period of 18 months. Be given credit since, I misread that. There was 12 days that he got credit for. Oh, okay. So jail time credit would be, as of today, 60 days, and that is calculated. It would be 71 days since the arrest. Actually, I'm beginning to think that math is not quite right. Let me look at this again. 31, 30, today is 10. Yep, it is right. 71 days minus 12 is 59 days. And they give one more day for today. So that'll be 60 days, yeah. 60 days of jail time credit. And then the DRC will give you conveyance time between now and the date that you are received at the institution. Now, upon completion of this, Mr. Mion, the Adult Parole Authority may choose to put you under post-release control. They don't have to, but they can. If they do, you'll be supervised on the terms they set by a parole officer, and if during that period of time they determine that you have failed to comply, they could return you to prison to make you serve an additional period of up to 9 months for one or more violations. That is also the cap. However, if you commit a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, it has to be served consecutively the sentence of the new case. You're also ordered to pay the court costs, which judge grant execution is ordered, And if you fail to do that, that can be collected through various means, including levying on bank accounts, wages, earnings, or other assets you may have, including collections, which would add a 30% fee on top of that. Now, I see that there was a specification that Mr. Mion had $2,729 in his possession. Is that money in the custody of the sheriff?
Yeah, it's in the custody of the arresting agency, which would be the Greenfield Police Department, Your Honor.
All right. Well, then the court will order that that Greenfield Police Department pay that to the clerk of courts and put that in the entry or provide a separate entry. And then it'll be distributed as follows. First, payment of court cost. Second, payment of reimbursement for indigent fees. And then the balance to Mr. Mion, or whoever he may designate it to be paid to.
Thank you, Your Honor.
All right.
Yes, sir.
Anything further from counsel?
No, Your Honor.
All right, you're remanded then back to custody, Mr. Mion. Thank you.